Please, Your Lordship, paid for listing and review petition for withdrawal.
Huh?
I am paid for listing and review petition in the withdrawal column.
For withdrawal.
Okay.
When?
Tomorrow.
Tomorrow.
Tomorrow 26.
28.
The Lordship, this matter may be listed for motion on 28th.
Madam, I can't hear you.
Your Lordship,
I think.
Your Lordship, this matter may be listed for motion on 28/4. This matter relates to pension. Right.
Please, Your Lordship. Lordship, I beg to mention item number 19. Lordship, we filed an additional affidavit today. May it be kindly brought to record. Okay.
Supplemental is item 31 for motion.
May I please, Your Lordship?
Hmm.
This is a matter, Your Lordship. There are a series of litigations by the petitioner, Your Lordship, seeking his transfer from Borpeta to Your Lordship to a school, Your Lordship, near his hometown at Chicago. Now, Your Lordship, initially, Your Lordship, and he came before this honorable court, Your Lordship, there was a direction to consider his prayer, Your Lordship. Thereafter, that prayer not having been, Your Lordship, considered, Your Lordship, he again come by way of a writ petition, Your Lordship. That is at page 33, Your Lordship.
Which order?
Page 33, Your Lordship.
No, which order you are challenging?
No order has been challenged by the petitioner, Your Lordship.
Huh?
No order has been challenged by the petitioner, Your Lordship. What he is praying for, Your Lordship, that there is a vacancy, Your Lordship, at Jorhat Higher Secondary School, Your Lordship. Now, after, Your Lordship, this one round of litigation, Your Lordship, they came up with a notification, Your Lordship, asking people to, teachers to, Your Lordship, submit online application for transfer. Now, he submitted an application, Your Lordship, online, Your Lordship. Now, that has not been considered till date, Your Lordship. In the meantime, Your Lordship, they advertise the subject teachers post in different parts of the state, Your Lordship, and that included post in Jorhat, Your Lordship, where he is seeking transfer, Your Lordship. Now he is praying before this honorable court that till his prayer is considered by the competent authority, Your Lordship, as per the law, Your Lordship, this particular act that has come up, Your Lordship, that post may not be filled up. That's what, or before filling up that post, Your Lordship, his prayer should be considered. This is his prayer in this petition, Your Lordship.
Now you have submitted a representation.
Yes, Your Lordship.
That representation has not been considered.
That has not been considered. Then what happened, Your Lordship? Then an advertisement was issued, Your Lordship, for filling up different posts, including the post originally he is praying for, Your Lordship, that is at Shivsagar. Now he came before this honorable court, Your Lordship, and honorable court directed, Your Lordship, that before filling up that post of Shivsagar, Your Lordship, in Shivsagar, Your Lordship, that his representation should be considered. That is at page 33, Your Lordship. May kindly peruse that order, Your Lordship, for a moment, Your Lordship. Now they did not comply, Your Lordship. They filled up that post, Your Lordship.
Which post? Shivsagar.
Shivsagar. In spite of the fact that there is a directions from this honorable court to consider his case before filling up that post, Your Lordship. That they did not, Your Lordship. Then, Your Lordship, they issued a notification asking the teachers to submit online application for inter-district transfer. Accordingly, I applied, Your Lordship. Now this time for a post at Jorhat, Your Lordship. Now that is also pending, Your Lordship. They have not considered. In the meantime, that post also advertised by the authorities, Your Lordship. Now my apprehension is that if once that is also filled up, Your Lordship, virtually my prayer will become redundant, Your Lordship. That's why I am before this honorable court.
No, your prayer would be redundant is a different aspect.
Lord.
You may also ask for the not for sale of the Hyderabad
No,
Charminar also.
that,
I'm not on that.
No,
But first of all, you have to have a right.
Lordship,
What is your right?
Lordship, under this particular act, your Lordship,
The regulation of 2020.
no, 2000 act, your Lordship.
That this act,
Yes, your Lordship.
this transfer and posting of
Yes,
elementary
Your
school teachers.
Yes, your Lordship.
Now, that does it give a right on submission
No,
of a
that is not
representation?
right. That is not a right, your Lordship. But if your Lordship will kindly see that that made a provision for your Lordship transfer on certain conditions, your Lordship.
Absolutely.
And they have,
Now, whether you fulfill that,
yes, your Lordship. That's
show
what
me that
your
that you
Lordship,
fulfill that.
if your Lordship comes,
Where is that act?
act I have not annexed, your Lordship, but I have copied.
Hmm.
Ground for seeking transfer under section 10, your Lordship.
What is it?
It says teacher may seek transfer only on the following ground: that for change of residence due to marriage, for looking after elderly and ailing parents, for safety and security of female teachers, for treatment of teacher and other dependents, for reasons mentioned in section 7. Section 7 says, your Lordship, a teacher working in a district continuously for 10 years or more can apply for transfer to his or her home district or to nearest contiguous district. Now, I have applied for that and I have completed 10 years of service.
What is your home district?
Sibsagar, your Lordship. Now, Sibsagar has been filled up. Now, only post available, your Lordship, either in Dibrugarh and Jorhat. And after filing of this petition, your Lordship, there are certain more developments, your Lordship. They have published a provisional list, your Lordship. And for Jorhat and Dibrugarh, there are no candidates, your Lordship. That has also, they can consider, your Lordship, my case. And your Lordship will kindly see, they themselves has invited me to.
No. Question of staying any advertisement or any appointment on the basis that you have a right to submit a representation cannot be done.
No, your Lordship, that's why my prayer is, your Lordship, that before they fill it up, your Lordship, they should consider it. It is pending since August 2022, your Lordship. They could have considered it any time, your Lordship.
And what is this order which has been enclosed out here of some order?
Yeah, that is page 33, your Lordship, order.
No, not that. There is some order being passed.
That is,
Yes.
your Lordship. They say,
Annexure F, page 40.
that is the order, your Lordship. They have,
Your name is what? Srimanto Kulta.
that is. Your Lordship, they say that they will consider my case, your Lordship, once this act and rules come into force. Your Lordship, may kindly come to page 41, last part. And your Lordship, both these conditions, your Lordship, mentioned in this order has already been fulfilled, your
No, after this,
Lordship.
19th of April 2022,
Lordship.
you submitted another representation.
That is, your Lordship, will kindly come to page 43. This is the notification issued by the Secretary of Assam, whereby, your Lordship, it is notified that the online portal shall remain open till so and so date, and teachers can submit application for intra and inter-district transfer. And accordingly, your Lordship, on online portal, I submitted my application.
Where is your application?
That is, your Lordship, online. It is required to be uploaded only, your Lordship, in particular format that I have done. Then, your Lordship, it is pending, your Lordship.
Now, how do you know that there is an online application?
I have made a statement on oath, your Lordship.
What is this? 6/3/2022?
Then, your Lordship, this 27/12/2022 is the next advertisement, your Lordship. Now, in this advertisement, the post at Jorhat is also included, your Lordship. And 6/3 is the last representation, your Lordship. I am submitting before the authorities, your Lordship.
How do you complete 10 years?
Your Lordship.
I've been working as postgraduate SMEs at Borpeta High School since 17th of August 2017.
2007.
Then,
Lordship, that aspect, Your Lordship.
and what is your ground?
Lordship. Yeah, otherwise also, Your Lordship.
Now, otherwise, what ground? Your parents are there.
No, Your Lord, that is there, and my wife is there, Your Lordship. My home district is there, and Your Lordship will kindly see, Your Lordship. They themselves has in the order said that it will be considered after completion.
Provided you comply with the criteria.
Lordship.
Do you comply with the criteria?
Here, Your Lordship, if Your Lordship, section 10, Your Lordship, ground for transfer, Your Lordship will see, Your Lordship. Teacher may seek transfer on following grounds, Your Lordship.
Hmm.
Apart from for change of residence due to marriage, for looking after elderly and ailing parents, for safety and security of female teacher, for treatment of the teachers and other dependents, for reasons as mentioned in section 7. Your Lordship, irrespective of section 7, Your Lordship, a person can apply, Your Lordship. If I don't fulfill, Your Lordship, the reasons under section 7, Your Lordship, even then under section 10, Your Lordship, I can apply, Your Lordship.
Very well. But if it is a vested right,
No, Your Lordship, it cannot be a vested
then
right. That's
if
why.
you don't have a vested right, where is the question of you being staying in a process?
No, I have not prayed for staying of the process. What
Then?
I am praying for, Your Lordship, before Your Lordship filling up that particular post, Your Lordship, before filling up that particular post, they should dispose of my petition, Your Lordship, that I have applied, Your Lordship, submitted through Your Lordship online portal. That much, Your Lordship, not more than that. And Your Lordship will kindly see another aspect, Your Lordship. Earlier also there was a direction from this honorable.
No. This court may direct many things. That is a different thing. But if you are asking this court to direct,
No,
it's a different thing.
No, Your Lordship.
First of all,
I have not directed.
You see, your only case is a case of legitimate expectation in view of the provision.
Lordship.
But to have a legitimate expectation, you have to fulfill the criteria.
Lordship.
That's all.
No, Your Lordship, that is the issue, Your Lordship. Even otherwise also, Your Lordship, section 7 says 10 years. But section 10 says even on other grounds also one can apply. And I am applied for that, Your Lordship. That's why, Your
No,
Lordship.
if that is the
And your
reason, then why did you take an appointment out there in Borpeta?
No, Your Lordship.
You have only completed 6 years.
Your Lordship will kindly see another aspect, Your Lordship.
Not even 6 years, less than 6 years.
That in Jorhat, Your Lordship, they have advertised the post. This is
And you have approached this court in 2020 initially.
initially.
That means within
That
3
was-
years, you don't want to remain in Borpeta. Give the post to somebody else.
No, Your Lordship.
They'll
that
be
is
happy
not
enough.
the case, Your Lordship. But only thing, Your Lordship, will kindly see, Your Lordship, even otherwise also, Your Lordship, this post are still, Your Lordship, no one has applied in this post, Your Lordship, in Jorhat and Dibrugarh, Your Lordship.
That is immaterial. Nobody has applied. There is a vacant post out there. That is a different thing. But you have only been there only for 6 years now.
But Your Lordship, since
And
this-
you moved the writ petition in
that is, Your
2020.
Lordship, in
And they have already considered that aspect of the matter earlier. Earlier, when the order was passed, that was duly considered at page 41,
considered, Your
42.
Lordship, after
And how many
consider-
times do you want the same
Your
thing?
Lord-
This
Your
court
Lordship
should
will-
ask.
If Your Lordship sees the order, Your Lordship, they say that after Your Lordship completion of the appointment process and mutual transfer, then Your Lordship, it will be.
No, you don't come
My-
within the ambit of a mutual transfer.
No, I don't. Your
No.
Lordship. That's why, Your Lordship.
So the only question you come in is that as regards your ailing parents who are there.
Lordship.
Now, okay, now what is the
Your
age of
Lordship,
your
may
parents?
Kindly see the order again, Your
What is
Lordship.
the age of your parents?
Age of parents, Your Lordship, I have not mentioned in my writ petition, Your Lordship.
What is the ailment?
I have only said that aged parents as also, Your Lordship, my wife, Your Lordship.
So wife, you can very well bring it.
No,
Is she working there?
Yes, Your Lordship, in a college in Shivsagar, Your Lordship. In a college in Shivsagar, Your Lordship. That's the problem, Your Lordship. Otherwise, Your Lordship, we would have, Your Lordship. And the order, Your Lordship, at page 30, 40, Your Lordship has already gone through, Your Lordship. It says, after completion of mutual transfer, appointment of new teachers, which has been advertised by Director of Secondary Education Assam and subsequent rationalization of teachers based on PTI, the transfer and posting of
Mr.
others.
Khatunia, what do you say?
He has already submitted an application.
Hmm?
He has already applied online, my lord.
Hmm.
So his case will be definitely considered, my lord, because he has submitted his online application. When his turns come, my lord, obviously.
You get your instructions to the,
Yeah.
as to whether his application has been considered.
Yes, my lord.
Heard Mr. S. Bhattagu, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Khatuni appears on behalf of the respondent number 1 and 2. Issue notice making it returnable. When can you get your instruction?
10 days, my lord.
You'll have it on 8th of May.
Yes, my lord.
Issue notice making it returnable on 8th of May. As the respondent number 1 and 2 is duly represented by Mr. N.J. Khatuni, extra copies of the petition be served upon him during the course of the day. As regards the respondent number 3, steps be taken by way of registered as well as usual during the course of the day. The case of the petitioner herein is that the petitioner, pursuant to the order dated 9th of August 2022, had submitted an online application for transferring him to his home district or a nearby home district on account of the difficulties faced by the petitioner. As the said representation has not been, as the said online application has not been considered, the petitioner had also submitted a representation on 6/3/2023 to the Director of Secondary Education. However, nothing has happened for which the petitioner has approached this court. Mr. N.J. Khatuni, the learned counsel, appearing on behalf of the respondent number 1 and 2, shall apprise this court as to whether the petitioner's application for online transfer has been considered by the respondent authorities. It is relevant to mention that the online application filed by the petitioner bears number -inter/SE-002-40910.
My lord.
Sir, I'm sorry, Your Worship, if I made a wrong statement regarding that 10 years ago. Saying that deeply.
Daily list, item number 1 for admission.
Huh?
Kindly pass the photo method for time being.
Why? Is item number 1?
The scenario is on leg.
Yes, Mr. Dutta.
Well,
On the last occasion, I asked you
well,
that you see in the penalty order, you have not passed an order, thereby depriving of his pension or pensionary benefits.
well. Now, in regard to
Could you
that,
have done that?
yes, my reply is, my lord, in regard to pension, now the pension regulation 2018, when the dismissal or removal order is passed, my lord, the benefit of pension is statutorily taken away. So that's the provision under pension regulation, clause 29, your lordship will find that. Flag mark it, your lordship will find that. 29. An employee who is dismissed or removed or terminated from service shall forfeit his pension, provided that the authority higher than the authority competent to dismiss or remove or terminate him from service may, if such dismissal, removal, termination is those or other things. Now, when he was dismissed,
Hmm.
my lord, this pension regulation was not there. It has come in only in 2018.
Oh, then
Even then also, my lord, since pension regulation, pension scheme was not there, even otherwise also he is not entitled to get, because it has come only in 2018. Now, supposing they want to give some retrospective effect also, even in that case also he will not get.
no, this bar under 29
My lord.
comes into action when these regulation come into effect.
Exactly.
If it is not there, then
Then, my lord, pension regulation, pension scheme was not there earlier. So otherwise also he is not eligible to get pension, even at that relevant time.
so there was no pension.
No pension.
So the pension only has come later on.
2018.
So earlier,
My lord.
prior to that, there was the pension was not a
No, the pension scheme was not.
condition of service.
My- So far, merit, my lord, your lordship has seen. The last time my learned friend argued
Hmm.
that he was not allowed to give the facility of to be represented by the defense representative. I've seen the disciplinary proceeding record. My lord, he was asked to take the help of the representative. He said no. And in regard to the cross-examination part in against all the charges, he said, I don't want to cross-examine. Even he did not give any evidence. And the charges are really very alarming.
So your case is the question of gratuity does not arise because the proviso
Yes.
to section 7 to I think is this section or what? To the regulation
Regulation.
72(2) would only come in the case of an employee
My lord,
and not an officer.
not in office.
And you would also further submit that if a perusal of regulation 72 is looked into,
Well.
the authority, the who has done this regulation
Uh,
under
regulation.
section 30 of the SAR,
My
this is by the board of directors of Assam. The board of directors, in its wisdom, had applied the officer's entitlement is separately with that of an employee.
My-
So he is not entitled.
My-
And the petitioner's case is only for gratuity.
gratuity, pension.
Pension, there was no, your case is that the pension does not arise because there was no,
No
pension
scheme.
was not given
Yes,
prior to 2018.
exactly. Just come only in the year 2018 November.
Yes. Where is your senior?
This is court number 10.
Why the inquiry report dated issued by Iman as well as the suspension issued by Iman was dismissed from service by yes could not be said. Release the consequential service benefits of the petitioner, so and so and other. Family pension not necessary, gratuity no. Group insurance is there.
Group insurance, yeah. They have paid for that.
They will be
If,
entitled
if
to it.
they are entitled, my lord, they will get. There won't be any problem.
And you have filed your affidavit.
No, my lord, since the disciplinary proceedings before lordship, the records are also there.
Affidavit in opposition filed by respondent number 1, 2, 3, and 5. You have
Possibly,
filed.
possibly a file, my lord.
Yes, it has been filed on 15th of December.
Yes, it is there. Fine. Lordship, give me 1 minute time. Let me check.
It is there on record. One Manoj Kumar Das, who claims to be the general manager of the Assam Gramin Vikas Bank.
Where is our? Number is five.
Now, there is a provision of appeal also.
Yes, they have filed appeal and that is already been dismissed.
Oh, that was dismissed subsequently.
My lord, it was dismissed on. My lord, 2/3/2017. This one, page 111, 111.
But your affidavit is silent there. Why he is not entitled to the pension or anything else?
Lord, I don't have the affidavit in my file.
Huh?
I was thinking I did not file it. And even if it is filed, my lord, very half-heartedly, it seems.
But it is silent, absolutely silent. Why he is not entitled to all the other dues, like pension and all that. But anyway, it is a provision of law.
Only thing I can say, badly drafted one.
Oh, it was filed from your chamber, Siddhant Datta. He? Yes, he has filed it.
Not well versed. I am also responsible.
Huh?
I am also responsible because I am liable to settle it.
You don't have a copy of this affidavit?
I'll have to borrow from your lordship.
Have a look. Hey, second copy. That is why Mr. Mohanto has been submitting not much on the disciplinary proceedings. Because you are completely silent on the regulation 72. You have a look at it. We will take it up some other day
Well,
as they are not there. Take a copy of it. Yes, your name, madam.
P. Soria.
B. Sohoria appears on behalf of the petitioners. Mr. C.C. Dutta, the learned senior counsel, assisted by Mr. S. Dutta, appears for the respondent numbers 1, 2, 3, and 5. And none appears for the Assam Gramin Vikas Bank. The learned counsel appearing on behalf of the respondent numbers 1, 2, 3, and 5 had submitted that it was only in the year 2018, that is on 8th of November 2018, that the Assam Gramin Vikas Bank employees pension regulations came into 2018 came into effect. It is the submission of the learned senior counsel that prior thereto, there was no pension so granted to its employees. Further, he referred to Regulation 29 to submit that even if the said regulation is made retrospectively applicable, then also the petitioner is not entitled to pension in as he had been dismissed or removed or terminated from service. As the learned counsel appearing on behalf of the petitioner, Mr. P. Mohanto, is not available today, that the matter be listed on some other date and be listed again on. When do you want it, Mr. Dot?
As convenient to your lordship.
We'll have it on 24th of May.
My lord, can I submit the disciplinary proceeding record?
Not now. We'll take it on that.
Much over.
Yes, Mr. Katuni.
It's a matter regarding my lord.
Establishment charges.
Yes, madam. I'd like to refer the item number.
Item number 2 to 12.
Item number 2 to 12, madam. I would like to refer from item number 4, madam. 6141 2018.
Yes.
Madam, in the year 2016, madam, the new rule has come, madam. Then the taxing system, earlier it was postpaid, and post 2016 it was prepaid, madam. So, in the new rule, the concept of establishment charge, concept of establishment has been abolished, madam. Earlier in the
No. You were to pay the establishment charge in terms of pay. Kindly come to page 18 of your petition,
yes, madam.
more particularly clause 9.
Yes, madam. Yes,
Till,
the excise establishment
yes,
posted at the erstwhile bonded warehouse, now wholesale warehouse license, shall not be withdrawn till the entire amount of area ad valorem levy and VAT on the transitional taxable underbound stock of liquor, including the stock in transit, deposited, and the licensee concerned shall be liable to reimburse to the government the salary, etc., of such excise establishment till they are withdrawn by the government on a non-due certificate issued by the concerned superintendent of excise or deputy superintendent of excise and the concerned superintendent of tax. So, my lord, here, on introduction of the new rule, my lord, they have constituted a joint team. They assess the underbound stock, my lord, and they have made a demand. Demand is at page 21. So, the total demand is 2,41,93,313 for levy, and for VAT is 1,59,11,922. Subsequent dear to my lord, Annex C, I have paid the entire amount, my lord. Annex C is the total amount, my lord, the last column, my lord. This is the total amount I have paid, my lord. Here is an amount of rupees 10 lakhs, my lord, which is for unsellable stock, my lord, and which, but that stock was chemically examined and it was found that it is not fit for human consumption. So hereafter, my lord, there was a report from the superintendent of excise at page 25. Report from the superintendent of excise at page 25.
yes, I've seen it.
Four.
Where it has been said that there is no other amount payable.
Yes, madam. As on date, there is no dues pending against the transitional sellable stock in respect of Messrs. Hillview Bonded Warehouse. In fact, after the waiver of ad valorem levy and VAT against the identified sedimentary stock, there will not have any pending liability on the part of the licensee. तो मतलब
Mr.
as
Pathak,
on-
what has happened to that case?
Your Lordship, that we were directed to the show cause notice for earlier show cause, second show cause notices were set aside, and we were given liberty to undertake a fresh exercise. That process is underway. There are a huge number of warehouses, Your Lordship.
Now, your case at which was the second BIO investigation, which was found. This court had only set aside the penalty as well as the show cause notice proceeding because you have not given him the copy of the BIO.
Lordship.
And this court further made it very clear that this court is only touching on these two aspects because of violation of the principles of natural justice. However, gave you the liberty. And at that point of time, while I had given you the liberty, I had made a specific query upon you that is it still possible after a period of 6 years, whether it is still possible? Then you said that yes, it is still possible because of those documents are there.
And because the staff are still posted at the warehouse.
And that stuff is still there.
Yes. This is the issue now, Your Lordship. Now,
Mm.
Your Lordship.
That is why on that day, Mr. A. Bolwa appeared
Lordship.
in this matter. I asked for you because you were conversant with that matter because that proceedings are still continuing.
We are still continuing.
Now, you have issued a penalty then, which was set aside by this court. That's a different thing. But once you have issued the penalty, you have still continued to maintain the establishment. Why?
Because the notification says, Your Lordship, that till a no due certificate is given, because along with the penalty, there was a demand also for the balance. So till the final excise and VAT is paid, Your Lordship, till that on the earlier duty and unpaid stock, till that point the excise staff will remain at the warehouse, Your Lordship. That's what the notification says. And clause 9 per se, or in fact even the whole notification is not under challenge, Your Lordship.
That notification is not under challenge.
And that is not under
That is what
they are trying to project before Your Lordship is that since they have paid an amount which according to them is the final amount, so the staff should be removed and they are not liable to pay any more. That is their projection. And our stand would be that till that amount is the final, there is some finality to those proceedings, Your Lordship, till this
there's a
that-
quietus. A
Yes.
quietus is received in
Yes,
respect to
till
those.
then
proceedings.
staff has to be maintained, Your Lordship, because particularly in the sale of intoxicants, Your Lordship, we have a duty on not only for revenue, Lordship, but also to ensure that there is no harm caused to the public as well, Your Lordship. So it is very important for us.
No, from there, wholesale, I don't think the public purchases.
No, if unconsumable stock, Your Lordship, for example, is released into the retail chain, Your Lordship, then perhaps.
But your Excise Act of 2016 does not emphasize that aspect of the matter.
But the Act does protect, Your Lordship, actions taken under the earlier East Bengal Act. So since this was a notification issued after the Act came into force, but for the rules, so perhaps it will be protected, Your Lordship.
No, this notification was issued prior to that.
On 29th of August.
29th of August.
29th
Act
of
came
August.
into
Act came into force from 1/7,
Once,
1/8,
1/9.
After the
1/9.
1/9. The savings clause will perhaps protect this action, Your Lordship. And otherwise also, this is a notification, Your Lordship, where we are saying that you have to pay the establishment charge. Unless they challenge the notification itself. They are not challenging the notification. Clause 9, the bare reading says that till the final amount is not paid and a no due certificate is not issued, the staff will remain. They are not
No,
challenging.
your specific case is that the no due certificate which was issued, that was not a proper no
That was
due
not a proper-
certificate because subsequently it was found that for a BIO investigation, it was found that there was a misappropriation of a huge amount
Huge amount.
and for which there is a requirement of getting the dues
Yes.
which you are entitled to,
Yes, sir.
which were not shown
Yes.
by that thing.
Yes. And in fact, the petitioners in item number 2, 5, 6, 7, 8, and 10, They were before your lordship in the last round also.
That is why 4 is making this submission.
Yes, 4. That is why 4 is making this submission now. your lordship.
Concept of exclusion is, my lord, to earlier, my lord, whatever stock in the warehouse does not duty paid. So in order to constrain the defalcation of government revenue, my lord, at that time, my lord, there is a concept of establishment. They posted the excise officials in the
But you have not challenged Rule 9,
no, my lord, because we are not agreed by clause 9, my lord. We are not agreed
which
by clause
says
9
that till they receive the amount.
because we have paid. Here, my lord, we have paid the amount. It's not the case that we have not paid. We have not paid that amount which is for unsellable stock. In fact, in the earlier proceeding, they have filed an affidavit. In the BOA proceeding, they have filed an affidavit. They say that they moved to the finance department to waiver this amount, my lord. But due to COVID situation in that time, my lord, that was
They
not
did
done.
not. They said that this can't be done because of the things that for
COVID
excise,
situation.
if we don't take that excise duty, it would be difficult for the state to sustain the COVID measures.
Exactly, my lord. So that was the stand in that proceeding, my lord. So here, my lord, we have paid the entire amount. Whatever amount is due for the sellable stock, we have paid it. And it has already been gone from the warehouse, my lord, to the retailer. So whatever stock is there, there's a sedimented stock, my lord. And chemical report is also there, my lord. It is the duty of the commissioner to pass the destruction order. But on the other hand, they are not issuing the destruction order and they are demanding establishment search from us, my lord. From last 6 years, my lord,
Have
they
they
are
filed the affidavit?
Yes, sir.
What
And
is
they
the
are standing-
reason they are saying?
limited, my lord, clause 9. They are relying on the clause 9 only. Nothing else.
That obviously they will rely on that.
Nothing
But
on
is
that.
it they
And
stand?
we are not agreed by clause 9, my lord, because we have paid the entire amount.
Paragraph number 4. Your lordship.
Starts and finishes.
It's a very short affidavit.
You don't have a case.
Apart from this, your lordship.
This paragraph 4 does not say anything.
Paragraph 4 says that, your lordship,
It says what?
by
You
the
have
said order-
no. Paragraph 4 is in respect to the joint verification team.
no, it also says, your lordship, just
Yeah.
one sentence, the last sentence.
Yeah.
It's otherwise a very concisely drafted affidavit.
Concisely.
Therefore, there was by the said order, it was decided that any unfit and dead stock found in the erstwhile bonded warehouse, the same shall be dealt with as per established procedure. Therefore, there was a necessity for excise personnel to be present in the said warehouses till the final completion of the entire process. Thus, till such time that the excise personnel are posted in the erstwhile bonded warehouses, the petitioner is liable to pay establishment charges to the
But tell me, Mr. Pathak, you're right
lordship.
to appoint or to keep the some establishment in the warehouses
Lordship.
was on the basis of that order of 29/8/2016,
Lordship.
which stipulated that a joint verification team shall make the verification.
Lordship.
Now, once they made the verification and the payment was made thereupon, don't you think that the matter is over for the purpose of that notification?
Lordship.
Are you not extending that beyond on the grounds of some other, as regards a BIO or anything which have been done, which is not a part of your case at all?
Lordship, perhaps we might have exceeded the terms of that notification, Lordship, by keeping the excise personnel there. But when we are dealing with a substance, an
No,
intoxicant,
isn't it required for issuing another order for that purpose? Because that order of clause 9 is only as regards the joint verification team. And the joint verification has been done. More so in view of your very, very concise affidavit.
but if clause 9, your Lordship, is read, your Lordship, individually, it says that till the entire amount of ad valorem
Absolutely. Entire amount from where? From the joint verification.
Though the notification says talks of a joint verification, clause 9.
And in
writes-
fact, that is made clear by your paragraph 4 of your very, very concise agreement affidavit.
Lordship, I think clause 9, Your Lordship, will have to be read individually, Lordship.
How
Because,
can you read it individually? Because clause 9 is otherwise not a part of the statute.
no, it is not.
It is on the basis of that verification to be conducted.
Yes.
So once the verification is over and in terms with that the payment has been made, can you further enlarge the scope of clause 9 to beyond anything else? It is only in the exigency of that aspect which have been mentioned. I hope that is your argument.
Yes, my lord. In fact, my lord, they didn't challenge this notification, my lord. By this notification, before coming into force the rules, my lord, they have put tax on us, my lord, which is not permissible otherwise. So they have
But
not challenged this.
for that purpose, if you want to do it, you have to issue a separate notification for that or do whatever maybe. For having an establishment in the warehouse, which is otherwise not permissible as per the.
We can issue a fresh notification, Lordship.
You can issue now, but how can you ask for the period earlier?
The thing is that, Your Lordship, what they are claiming now, Your Lordship, is that the amount that what they are claiming is that the amount that is been paid by them is the final amount, Your Lordship.
Absolutely. No, they are saying that look at this is a notification which was issued because at that point of time, their bonded warehouse, the business where they were carrying out was a bonded warehouse, and wherein there was a goods stored which are not tax paid. Subsequent to the 2006 or 16 Act, their warehouses as it was did not have the manufacturing with them had become a warehouse, wholesale warehouse, and there it is required to keep the even tax paid goods. Now, for that purpose, it was required, the authorities understood it, and for which there was a joint verification team constituted pursuant to the orders of the governor to that effect. And in that thing, it was mentioned that till the joint verification is made and whatever amount is found out is not paid, there will be a persons or certain personnel be kept and they would have to pay. Now, once the joint verification has been done, the payment has been made, how can you still charge them with the establishment of charges? If you have done something as regards BIU or found out something to that effect, then very well you can charge them for that by issuing a separate notification, but that has to be within the contours of the Act of 2016
Rules of 2016 and Act
rules,
of 20.
Act and rules.
Yes, ma'am.
I just need to seek instructions if any fresh orders have been issued pursuant to this, because this affidavit was also filed way back, Your Lordship, in 2019 itself. So since then, there might I'm not sure about this, Your Lordship, because I need to seek instructions if any fresh orders have been issued.
Because you can't enlarge, because once the joint verification team was over,
Yes, sir.
verification made, payment has been made, the scope of section 9 or clause 9 has come to an end. Now, at present, if you want to do it, while doing that, you can very well, but they will then challenge it because the Act of 2016 and the rules does not prescribe something to that effect.
Your Lordship, though this notification talks about constitution of a joint verification team, Your Lordship, it does not say, Your Lordship, each of the clauses, Your Lordship, after clause 3 onwards, they say that the entire amount of ad valorem levy has to be paid. Nowhere says that the amount of ad valorem levy as found out as determined by the joint verification. So, Your Lordship,
Now, who is going to, you see,
clause 3, Your Lordship,
now who is going to, the entire, now kindly see not that, the clause, kindly see clause 1.
Clause 1. Joint team constituted as per government order shall take stock of all such transitional stock, underborn stock of liquor stroke spirit in the erstwhile bonded warehouses, now wholesale warehouse licenses, as on the date preceding the date of the new excise, Assam Excise Bill 2016 coming into force, including the stock date of the new Assam Excise Bill 2016 coming into force, including the stock in transit, the value of such stock as per books of accounts, and shall calculate and record the government levies involved on such stock, including the ad valorem levy and VAT as per the Assam Excise Bill 2016 and the Assam VAT Act 2003 as amended. The head of the joint team shall then furnish a report to the Excise Commissioner and Commissioner of Taxes within 3 working days of the Assam Excise Bill 2016 coming into force. A warehouse-wise list containing
Then you see 3A.
3A.
This is the report to be submitted by the head, then
Yes.
3A.
3A. On receipt of such report from the concerned head of the joint team, the Excise Commissioner shall pass an order to the effect that the entire amount of ad valorem levy involved on the transitional taxable underborn stock of liquor be deposited by the licensees of the erstwhile bonded warehouses, now wholesale warehouse licensees, at the rates applicable under the new Assam Excise Bill 2016 within a period of 3 months from the date of coming into force of such bill. On receipt of such report, the Commissioner of Taxes shall also pass an order to the effect that the entire amount of VAT involved in the transitional taxable underborn stock of liquor be deposited by the licensees of the erstwhile bonded warehouses, now wholesale warehouse licensees, at the rates applicable under the Assam VAT Act 2003 as amended. The Superintendent of Excise of the concerned department shall submit daily report to the Excise Commissioner and the Commissioner of Taxes along with a copy to the concerned Superintendent of Taxes showing warehouse-wise amount of area ad valorem levy and VAT realized on that day.
So this is finalized.
Yes,
After the report by the head, the excise commissioner will pass an order, and this will be then foreseen by the superintendent of excise. Then kindly come to 5.
entire amount of ad valorem levy and VAT on the transitional taxable underborn stock of liquor as on the day of the Assam Excise Bill 2016 coming into force, including the stock that has arrived subsequently on the strength of permits issued before the Assam Excise Bill 2016 came into force, shall be realized within 3 months from the date of notification of the new excise goods. If any erstwhile bonded warehouse, now wholesale warehouse licenses, fails to deposit the entire amount of area ad valorem levy and VAT within that period, his wholesale license shall be liable to be cancelled and the stock therein shall be liable to be confiscated to the state. So there are two aspects, Your Lordship. One is the amount, Your Lordship, which has been lying in their warehouses, and the entire amount of ad valorem levy and VAT on the transitional taxable underborn stock of liquor as on the day of the Assam Excise Bill 2016 coming into force, including the stock that has arrived subsequently on the strength of permits issued
So you will take the entire amount within 3 months.
within 3 months.
And if they don't pay, you'll either cancel the license or confiscate the stock.
Yes.
So this period is 3 months from there, from the date of the order.
From the date of the order.
Okay. Then you see 6. In case of presence of unfit or dead stock in the erstwhile layman, the same shall be dealt with as per the procedure established on the specific report from the head of the joint and on case-to-case basis within 3 months period. Again, the same 3
Within
months.
this 3 month period.
Godown or the allowance shall be allowed as per the established on the specific report from the so and amount of the taxes on warehouses to warehouse basis within 3 months. All applications for import shall be governed by the so. Now see now, the excise establishment posted at the erstwhile bonded warehouse now so shall not be withdrawn till the entire amount of ad valorem and VAT on the transitional under bond stock of liquor, including the stock in transit deposited and license concerned, shall be liable to reimburse to the government. So this is has to be in relation to that. It can't be something else. Subsequently, in 2017, you made a what you call searches out there.
Yeah.
And thereupon have issued notice, imposed penalties. Those are different aspects of the matter.
Lordship. If, only
There might be an extension of this.
Yes, sir.
Maybe.
there may I need to see.
So that is another aspect of the matter. If there has been an extension, if there is no extension, then the matter ends.
Yes, your lordship.
Because you see why there might be an extension, because in many of the cases, as I remember there, while dealing with those, they were given certain installments.
They were allowed to pay in installments. Yes.
If they were paid directed to pay installments, obviously this clause 9 must have been suitably taken care of.
I need to see.
That might be the only reason. Otherwise, you don't have a case. They have a case.
Extension was given, my lord, regarding payment of duty in installment, my lord. But there is no extension with regard to the clause 9, my lord.
No, clause 9, it isn't different. But you see, clause 9 initially conceptualizes a period of 3 months, but also conceptualizes that till the payment is over. But one thing is apparent. The clause 9 is a thing which mentions about a verification to be conducted by the joint verification team and not by the BIO.
In fact, my lord, we have made the entire payment in the month of March 2017.
Here in poor you have, not others.
Yes, my lord, in other also, my lord, I have.
No, not others. Others is some 3 months, 4 months were there.
Yes,
You were given some installments.
yes.
One was a case of some, if I remember, that item which the lead matter which I had taken was some Jasrasaria matter. He's not here.
A visit international.
That Avijit International.
But here also I have paid. In fact,
When did you pay? Did you pay in installments?
yes, I
You
have
paid in installments.
completed the payment, my lord. On 30/11/2017, my lord.
See? 30/11/2017.
My lord.
So that is, it is extended till 30/11. You were supposed to pay by 2016, 3 months.
Thereafter, they have given extension, my lord.
That is what I'm saying.
Yes,
The
yes.
moment extension is given, clause 9 comes in. So till then, you have to keep on paying the establishment charges, not after that.
Yes, my lord.
So your case would be that this clause 9 is only in respect to a joint verification.
Yes.
If anything else they have done it, let them do it. That is their concern. If they want to keep somebody, they'll have to pay from their own pocket. You need instructions?
Yes, your lordship.
When?
Tomorrow, by tomorrow also, your lordship.
Tomorrow. And it's a bit of both matters, no? And 9. That was on second. How many? Had Mr. N.J. Khatunia, the learned counsel, appearing on behalf of the petitioners. Yes, madam, you are appearing. Together. Ranbora? Yes. And so appears on behalf of the petitioner in WPC number? And so Mr. K.P. Pathak appears on behalf of the Excise Department of the Government of Assam. The issue involved in the instant proceedings pertains to as to whether the petitioners would be liable to pay establishment charges as imposed upon them by various notices in terms with clause 9 of the order dated 29/8/2016. It is the case of the petitioner that the establishment charges which the petitioner is required to pay in terms of clause 9 is only till such time the amount payable in terms with the report so submitted by the joint verification team and on the basis of which the excise commissioner passes orders is not paid. Once the said amount have been duly paid, the question of further imposing upon the petitioners the establishment charges does not arise. It is the specific submission of the petitioners that the petitioners have duly paid the excise levy. So assessed by the excise commissioner pursuant to the report submitted by the head of the joint team.
On the consumable stock matter.
However, as regards the unfit or dead stock, it is the case of the petitioner that the question of payment of any excise duty on the same does not arise. In view of clause 6 of the said order dated 29/8/2016. Inasmuch as it has already been certified by the concerned authority that such stocks are not fit for human consumption. The learned counsel further submits that the entire amount of area ad valorem levy and VAT as mentioned in clause 9 is only in respect to the assessment being or the orders being passed by the commissioner upon such report being submitted by the head of the joint team and not in respect to the dead stock. On the other hand, Mr. K.P. Pathak, the learned counsel appearing on behalf of the excise department, submitted that although a perusal of the order dated 29/8/2016 shows that the amount is liable to be the amount so adjudged by the amount so directed by the excise commissioner in terms with clause 3A and 3B of the order dated 29/8/2016 was liable to be paid within a period of 3 months. But from the records as maintained in the writ petition, it would be seen that the said payment was being made, that the petitioners were given various installments, the petitioners were afforded the benefit of installments. And as such, the question of the payment of the establishment charges only for a period of 3 months, it does not arise. He further submitted that he would like to take instruction as to whether there has been any further notification, thereby extending the purview of extending the requirement of payment of the establishment charges as mentioned in clause 9 of the order dated 29/8/2016 beyond the period mentioned therein, that the matter be listed on 2nd of May 2023.
of license.
Thirteen.
Right.
Yes, Mr. Manan.
This matter basically, your lordship, the petitioner is seeking his pensionary benefits.
Oh.
And there was actually the fact of the case is that there was a departmental inquiry initiated against him
Why this matter has come up on a Tuesday?
because I don't know why, but anyways, your lordship,
There's some buy order matter.
no, yes, because of the earlier
What is this
also
buy order
twice,
business? Aligitai.
this was earlier, your lordship mentioned, but it has not reached, so it has come today. The issue, your
Oh.
lordship, basically is that the
Wait. Let us see why this buy order business comes on a Tuesday. Is it? Matter to क्या है?
because of the holidays, I think has been put on.
Holidays, no holidays, but why is it shown as buy order? Because I never give a permission
Your lordship has not. This is
for a
moved before the other senior bench, bench 3.
I
Bench
think
3 was
that
moved,
bench
and-
3
but it
should
was
take up
sent
the
with-
matter.
Yes.
Because you see, pension matters are exclusively reserved for Tuesdays, Wednesdays, and Fridays.
This
It doesn't
matter-
take much time for these matters.
because this is a pension matter.
Because otherwise, I don't fix these matters. Anyways, let us see what GMC.
GMC. What has happened, your lordship? The petitioner was appointed as Mazdoor, but he was LDA. He was finally in page 20. He was given his service as LDA. The matter starts from 2015. What happened, your lordship? He was placed under suspension in 2015. That your lordship will find at page 29. Page 29.
Yeah.
Pending royal of departmental proceedings, Sri Anil Deka, so and so, is hereby placed under suspension with immediate effect. Thereafter, your lordship, on 19/3/2015, the next page, page 30, he was given a
So-cause.
so-cause notice.
Then
So-cause notice, your lordship, in the second paragraph, you are hereby, second paragraph of the so-cause notice, that is the only issue here. You are hereby charged with gross negligence of duty and misappropriation of GMC money. No specific amount has been given, nothing has been given. So he was asked to reply. He replied, your lordship. I'm not going through the reply as of now. Then, your lordship, he made an application for payment of his subsistence allowance and also to inspect the documents. Your lordship will now come to page 36. Page 36 for a moment.
then
Page 36, in the month of August 2015, an order was made for 50% of his subsistence allowance. Initially, he was not paid the subsistence allowance. After about a period of about 6 months, he was directed to be paid the subsistence allowance at 50%. From the date, that is 19/1 to 18/4. That means that was also 4 months prior to the order. So that then 75 starts, but that was given subsequently much later, but it was not paid. So I am just shown it because these have not been paid. Now, your lordship will find at page 37, I approached this honorable court by a writ petition challenging the suspension order. This honorable court by order at page 37, the operative part page 41.
is
Last,
the only order of consider revocation.
yes, that was revoked. So it was
There was a
consider
direction to
revocation,
consider.
consider, and it was revoked.
Okay, then
Then page 42,
yes, then
then it was revoked. Now, after revocation of that, your lordship, I was not paid the subsistence allowance. I made applications for page 44 on 22/10/2018 for all my outstanding dues. And against this, your lordship, they have given a letter that is at page 46.
as a criminal proceeding is going against you in the court of law, your application cannot be considered disposal of the court case. So
What is
even
this
that
application of 2210?
22,
What are you asking for? In view
I'm
of the
asking for all the
Iman,
outstanding
being
dues
credited, it is hoped
with
that
regard
your
to DNS
books will-
allowance, page 45, first paragraph.
I have-
DNS allowance, area accumulated till date, house rent, medical allowance, etc. At that time, I was not retired. But subsequently, I retired, then pension also comes.
Then,
Then at page 46, they say that there is a criminal case pending. After the criminal case is disposal, my application will be considered.
so what are you getting? What pay you getting till 2019?
I was
Only
getting nothing.
subsistence allowance.
Subsistence allowance that was given much later after I have rejoined, after reinstated.
Hmm.
So I was given a subsistence allowance. Initial 50% was given for 4 months, 3 months. That was given. Subsequently, nothing was given to me. Then I was reinstated. I got my salary for that period. Then I retired. And after
So you got your salary then
that period, sir.
after reinstatement.
Yes, but I have not given the. I think there is an issue of not giving me the.
House rent.
Those were not paid. Those were not paid.
No, you didn't get that. You got only your salary, no house rent.
No, nothing.
Okay.
Then what has happened, your lordship? I retired, and this criminal case was also came to an end. And the criminal case, I was acquitted. I have annexed that at page. Your lordship will find
Page
it
60 onward.
page 59.
Then,
And I was acquitted from this case.
now
Then
what
I
do you
made
want?
the application saying that since I have been acquitted, now kindly pay all the dues that I have given at page 73.
Hmm.
All the revision of pay was not given. And then
Then,
allowances.
whereas an inquiry under section AR is being held.
Now, your lordship, what has happened?
Now,
Now, after about 7 years, after 7 years of the initial issue of suspension, now after my retirement, 2 years after retirement, they are issuing a notice to me, an order to me, saying that they are starting with the departmental act.
After
That-
2 years?
That they cannot.
Well,
My lord,
21. You come within the ambit of the pension rules?
My lord, in this case, my instruction is evident. My lord, 10 days.
No. Instruction can't wait. I'm only asking you a simple question. When did you issue him the so-called memorandum of charges?
That was, your lordship, on 19/3/2015.
Okay. Now thereafter,
Nothing happened. No inquiry.
no nothing. But in 2022 they appointed.
No, they reinstated me.
No, 2022 they appointed.
22.
Seven,
22, they have
Inquiry
appointed
officer.
after 7 years.
Very well. Then
Now I have come after that before your lordship, saying that
challenging what?
challenging both.
How are
The
you challenging the show cause notice? On the ground of delay?
yes. And I have come against the departmental inquiry, which was initiated on 19/3/2015 after 7 years, as well as for the other allowances and pay which has not been given to me. Even GPF gratuity.
Pay is okay. Those pay and all you will get it. But what do you say about how do you challenge the departmental proceedings?
Departmental proceeding, I am challenging on the ground that in the judgment of a very famous judgment of Premnath Bali, the Honorable Supreme Court has said that the departmental inquiry which is initiated by a show cause should normally be culminated within a period of 6 months. It can be beyond that for a period of 1 year if substantially it is shown that it is required. Here, what is the reason they have kept it for 7 years? So that is the ground that there is a delay. You have not done anything for 7 years. I have retired. When I have asked for my payment, now you have started with a new first an order appointing an inquiry officer. Now after 7 years, this is basically on the ground of delay, and you cannot do. You have got it, and the criminal case was there. The criminal case I was in. Fine. The both can go together, as your lordship know. They have not done anything for the. I have also replied to their so-called. Thereafter, they kept it pending. Whenever they have reinstated me in service after this court's order, and then nothing was done till I retired. After my retirement, when I came and filed before them that these are the dues which you have not paid. Now, after that, 2 years after my retirement, they have issued this order that no, we are issuing a departmental inquiry and they will not pay. This cannot be. This can because the judgment I will provide to your lordship 2016, 15 S. Premnath Balgi is a famous judgment where the Honorable Court has said directed all departments throughout to finalize a departmental inquiry within a period of 6 months. If not possible, to a period of 1 year. And that too, you have to give justified ground for the extension.
But in that case, whether there was a criminal case out there?
Their criminal case was, I think, in this Bali's case.
No.
I don't think so. Criminal case. Just a moment.
I think thereafter Bali's judgment, there are a few other judgments.
Judgment have come following this judgment. Bali's judgment, there are 1 or 2 judgments. Even I think 2021 there was a judgment. I did not bring that copy because it has followed this judgment.
You didn't bring because it has come up by order.
I have got this judgment. Bali's judgment, I think, will. And I'll just read one paragraph, Your Lordship. It has been, the court has very specifically stated that you have to. We are, this paragraph 25 to 28 are the relevant one. I'll just read one.
Yes, Mr. Nayak, what is the status of this thing, inquiry proceedings?
In terms of your lordship, last order, lordship.
Oh, there is no last order by me. Due to paucity of time, matter cannot be taken up today.
The preceding order. Prior to that.
Oh, my order. Mr. P. Nayak, the learned counsel, if submitted as per the instruction in view of the pendency of some criminal proceeding against him have been initiated against him. The learned counsel submitted he would file an inquiry in that regard. That was 4 months back.
Yes, Lord.
What happened?
Today morning, lordship, they have informed me that they are preparing the instruction, lordship, but they themselves are not satisfied with the
instruction.
Yes.
So we set aside,
no, lordship,
make payment.
No, as your lordship has already passed an order for instruction, lordship. I have already instructed.
No, that was given in the month of December.
Yes, whatever
we are in the month of May, almost.
No, lordship will see at page 71, lordship. He was acquitted only in the month of February 2022. Show cause notice was issued in the year 2015, but because of the pendency of the criminal trial, lordship, it was kept in abeyance probable, lord. That appears, lord. And once the criminal trial is over, lordship, he has been acquitted.
Understood. You have appointed whatever may be, you have appointed an inquiry officer.
Yes, lordship.
What happened thereafter?
That instruction.
Does it take so much of time for 4 months to get an instruction to that effect? As to what you have done thereafter?
Lordship, in terms of my letter, lordship, they have prepared one parawise, lordship. The legal, I mean, advisor of GMC, lordship, he is not satisfied with the parawise. The legal advisor, lordship.
I am not concerned with your internal affairs out there regards having a legal advisor or not. But why does it take such a time to apprise this court as what is the status of an inquiry? If you are holding an inquiry, is there a stay to the inquiry proceedings? No.
No.
Then why haven't you done anything in the meantime? By these 4 months from the last day, you could have finished up this inquiry in terms with the Supreme Court judgment. Matter would have ended.
Lordship will take up this matter then tomorrow, lordship.
Tomorrow, good.
Tomorrow. At least I will place the apprise your lordship.
Okay, heard Mr. Y.S. Menon, the learned counsel, appearing on behalf of the petitioner. Mr. P. Nayak appears on behalf of the GMC.
Lord.
Full stop. This court had made a specific query upon the learned counsel for the GMC as to what is the status of the inquiry proceedings so initiated against the petitioner. Full stop. The learned counsel appearing on behalf of the GMC submits that he would like to take instruction in the matter. It is relevant to take note of that by an order dated 5/12/2022, liberty was given to the GMC to file the affidavit, but till date no affidavit has been filed. Just taking into account the same, let the matter be taken up again for 2 o'clock tomorrow. List accordingly.
That's all.
You mention the matter tomorrow. Otherwise, it won't come. I mean, it will come, but there are many matters.
But at 2 o'clock, I'll mention. before.
Yes.
Yes.
14.
Vicky. Yes.
This is the matter for non-payment of area salary.
Why the matter has come up?
Because my lord, I have mentioned before your lordship, since my lord,
I don't remember giving any
yes, yes.
permission for
I
on
think
this date.
now some development has taken place, my lord.
25-4. You mentioned in before which court?
Court number 5, lord.
Then go to court number 5. I'll fix it before court number 5.
Oh,
Yes, yes. Very well. We'll have it in court number 5. Why did you mention in court number 5 and get a mention and do it here?
my lord, court the case, civil bench 3, my lord. Court the-
This court is not taking up civil bench 3, Mr. Counsel. This court is only taking up pension, area, suspension, all this. And if those falls within the ambit of this, then the mention ought to have been made before this court. But this mention has been mentioned before that court. Don't you see it here there? It is made clear. See? In the roster. Then court number 5. Yes. See? This bench will take up matters pertaining to other than matters relating to transfer, pension, suspension, payment of salary and allowances. That, what did you mention in that court?
This is a senior bench, my lord. That's why.
It is not the senior bench. This court doesn't have a senior bench for these matters which this court takes.
Sorry,
Okay, little. Heard Mr. D. Volva, the Learned Counsel, appearing on behalf of petitioner Mr. G. Bora, appears on behalf of the Learned Counsel for the Agriculture Department. First, list it before any other bench except me.
Okay.
Supplementary list, item number 32 for admission.
The order task. Good. Itu mata people too good. No, ada juga order task. Cuma takut cuma zaman dah takut. Cuma anyway, I'm ready. Where is Mr. the other person? Where is Mr. Dubey? Dubey? He's not around? Mr. K. Gogoi, not around?
Gogoi is on lag.
Hello, I'm coming in 5 minutes. Now, what will happen, Mr. Dubey? What will happen? She has received certain amount. Now, the deduction once she opts for the central pension scheme, then the amount which have been paid by the EFO, only the pension will be deducted, not the others. Now, the petitioner have already been paid an amount of some 33 lakhs.
Yes.
CPF amount of 1,38,000, gratuity amount of rupees 10 lakhs, group saving in linked insurance scheme 44,000, employees benevolent fund amounting to 1650 per month for 5 years, with effect from 1/3/2017, 93,000, earned leave 2,67,000 and 5,74,000. So what will be deducted is only the pension, which she have been receiving at the amount of rupees 11,000 something. 48. With effect from 25 to 2015.
17.
Huh? From 25 to 2017. 15. 25 to 2015, what she has been receiving. So So that amount will be deducted.
Yeah, I mean the instruction that she till March 2023, she has received 8,73,345 rupees.
So
Yes.
that amount will be deducted from, and she'll be entitled from 25 to, from when will be she entitled for the pension?
From 17.
17.
The regular pension will come from 17. It is a paper pension, so it was on since 15. EPS 95. Now the regular pension will be from 17, from the date of retirement.
Retirement happened on
Retirement or
12/1,
28,
12/1/2017.
no, 28 to 17.
28 to 2017. Means he retired on 28 from 1/3/2017. So from 1/3/2017, she will be entitled for
Regular
the
pension.
area pension of her husband,
Yes, and the regular.
as well as the pension from family pension. And from that amount, this amount of 8 lakhs will be deducted. That is it.
Yes, sir, that's it.
And what about the excess amount?
Excess in that from the pension, there is no excess part.
Huh?
Excess, there is no excess part. Excess part is that was calculated by the authority. That is different chapter. If drawn.
That is not as regard the pension part.
No. Initially, it was informed that an amount of some 1,24,000 is the 1,25,985 is the excess, which
lord.
has been duly paid.
My lord.
Then once it is being paid, then it was mentioned that a further amount of rupees 2 lakhs, another amount of rupees 1,31,385 remain,
My lord.
which is to be deducted, where the petitioner said that yes, the amount can be
yes, agreed.
taken once I get my pension.
My lord.
No, but that amount also already been deducted from the pension with medical pension. From that amount, that 1,31,000 has already been deducted.
That has been deducted.
Already.
So only consideration out here is this.
The second part has not been deducted, my lord. She has consented that when the arrear amount would be paid, my lord, that she is agreeable for deductions.
And that is now he says that that has been deducted.
No. Anyway, my lord, if it's not deducted or it's deducted, my lord, that can be left open, my lord. My lord will see, my lord, if that's adjusted, then no issue. If not, then it can be adjusted.
But how did this amount of 2,57,370 come in?
Well, it is basically when he was working with the civil aviation department, Lord, that calculation breaks down to Lord, that.
But can you do so in view of Rafiq Masih?
Lord, we have already done so, my lord. We have already done so, my lord. In respect of other.
You do for others, it's a different thing. But can you do so in view of Rafiq Masih? Because the person has already died. Thereafter, you have initiated this process. When he was alive, the petitioner's husband was alive, your claim was only 1,25,985. And he has duly paid that amount. Thereafter, after his death,
There was a recalculation, my lord, and
could you have done that? In view of section paragraph 18(2). But that has been deducted.
Yes, but that amount has already been deducted.
Let me not take into, not mention anything to that effect. Heard Mr. PCR Medhi, the learned counsel for the petitioner. Mr.
MK Majumdar.
You will come later on. Wait.
Yes.
Mr. K. Gogoi, is he there? Mr. K. Gogoi appears on behalf of the central government. Mr. R. Dubey appears on behalf of the Airport Authority of India. And Mr. M.K. Majumdar, the learned counsel, appears on behalf of the Employees Provident Fund Organization. A perusal of the writ petition transpires that the claim of the petitioner initially was for payment of the pension government pension to the deceased husband of the petitioner and for family pension. It transpires from the, it further can be seen from the perusal of the, further can be seen that the husband of the petitioner, late Manoranjan Roy, served under the Airport Authority of India for a period of 33 years, 9 months, 25 days, with his last rank of service as the Senior Superintendent, bracket ENM, normal name, M, bracket close, SG, in the Bojar Airport. The husband of the petitioner retired on 28/2/2017. Prior to his retirement, the husband of the petitioner on 12/1/2017 prior to the retirement of the husband of the petitioner, on 12/1/2017, a memorandum was issued whereby the husband of the petitioner was directed to submit an application for final payment of the retirement gratuity, CPF, GSLIS, and benevolent fund, etc., in a prescribed format. The husband of the petitioner duly submitted the required documents for getting his retirement benefit. It is relevant to mention that on 26/2/2020, a letter was issued by the senior manager, HR, Airport Authority of India to the husband of the petitioner, wherein it was written that during the service period, an amount of rupees 1,25,985 was overpaid to the petitioner, husband of the petitioner. It was further mentioned that the said amount is required to be deposited for the process, for the purpose of disbursing the government pension. During the lifetime of the husband of the petitioner, he had deposited the said amount of rupees 1,25,985 by the check bearing number 861128, dated 5/3/2020. However, in spite of the said deposit, the pension of the husband of the petitioner was not released. For which a legal notice was issued to the regional executive director of the respondent number 1 with a prayer to sanction and allow the government pension. Upon receipt of the said notice, on 10/8/2020, legal notice was issued to the heir. Thereafter, unfortunately, the husband of the petitioner expired on 21/4/2020. Subsequent thereto, on 10/8/2020, the senior manager HR, Airport Authority of India, issued a communication to the petitioner, wherein it was mentioned that the excess amount to be paid was rupees 2,57,370. And as only an amount of rupees 1,25,985 was paid, and rest of the amount of rupees 1,31,385 was pending, the said amount is required to be deposited by the petitioner. The petitioner, upon receipt of the said communication, submitted a reply dated 18/9/2020, protesting against the said demand so made, on the ground that such a demand ought to have been made during the lifetime of the husband of the petition. It was, however, mentioned that the said amount of rupees 1,31,385 would be returned only after receipt of the government pension to her husband, as well as the family pension to her. However, as nothing was done by the respondent authorities to clear the pension, to disburse the pension to the petitioner, the instant writ petition was filed seeking the relief, as already mentioned here in above. This court, by an order dated 12/3/2021, had issued notice. Pursuant to the said notice, an affidavit in opposition was filed by the respondent number 1, 3, 4, and 5. That is the officials of the Airport Authority of India. In the said affidavit in opposition, it was mentioned that the husband of the petitioner, as well as the petitioner, received a total amount of rupees 33,68,698. The details of which were: number 1, Roman 1, CPF amount of rupees 1,38,810. Number 2, Roman 2, gratuity amount of rupees 10 lakhs. Number 3, group saving linked insurance scheme, bracket ZSLIS, bracket close, amount of rupees 44,415. Number 4, employees benevolent fund scheme, amounting to rupees 1,560 per month for 5 years, with effect from 1/3/2017. That's rupees 93,600. Number 5, earn leave and half pay leave encashment totaling to rupees 2,67,710 and 5,74,872. It was also mentioned in the said affidavit that the petitioner's husband had already been sanctioned pension by the EPFO as per the EPS.95 scheme, and the pension payment order had already been issued by the EPFO via order dated 29/11/2016. It was also mentioned that the petitioner's husband had submitted his claim for pension under the EPS.95 scheme under the Employees Provident Fund Organization on 19/1/2016. And this request was scrutinized by verifying with the records maintained in the office of the Airport Authority of India. And all the copies of the documents were forwarded to the corporate headquarters on 10/3/2016 from the regional headquarters, Northeastern Region, Guwahati. The claim of the petitioner's husband was thereafter scrutinized by the corporate headquarters, New Delhi. And after verification, the claim was forwarded to the RPFC. That is, what is RPFC? Regional Provident Fund Commissioner. What is response number 10?
Yes. Commissioner.
Was forwarded to the Regional Provident Fund Commissioner. That's the respondent number 10, who is the nodal authority for sanction of pension under the EPS.95 scheme. And the respondent number 10 had sanctioned the pension at the rate of rupees 11,048 per month. And the pension payment order had already been issued by the EPFO by order dated 29/11/2016. It was further mentioned that the husband of the petitioner was getting a monthly pension of rupees 11,048 per month with effect from 25/2/2015. It further reveals from the reports that on 12/9/2022, when the matter was listed before this court, attention was drawn to this court to an office memorandum dated 11/1/2022 on the subject government pensionary benefit due to employees transferred en masse from the erstwhile Civil Aviation Department, CAD, public Director General of Civil Aviation, DCGA, to the Airport Authority of India, AAI, From the office memorandum, it can be noticed that the Ministry of Civil Aviation, in order to stop any arrangement of dual pension from two authorities, had impressed upon the Ministry of Labour Employment to take up the matter with the Employees Provident Fund Organization to favorably consider and stop the payment of EPFO pension to the government absorbees of AAI as a special measure so that AAI and DCGA can start processing the pension cases for issuance of government pension payment order. However, on account of non-resolution of the said issue, the petitioner, who is a widow of the AAI absorbee, have been receiving only the EPFO pension, which is at a rate much lesser than the pension she is likely to receive in the event of issuance of a government pension payment order. It is under such circumstances this court directed both the learned counsel appearing on behalf of the central government, had directed the learned counsels appearing on behalf of the central government, the EPFO, as well as the Airport Authority of India, to obtain instructions in the matter. It further reveals that on 28/10/2022, the learned counsel appearing on behalf of the central government submitted that pursuant to the order dated 12/9/2022, they had sent letters to the EPFO, but no instructions have been received from their end. Thereupon, the matter was again listed on 22/12/2022 before this court. The relevant portion of the said order is quoted here in below. It has the first paragraph to it has been brought to the attention of the last, taking into account the aforesaid, this court fixes the matter on 21/2020. Let the matter be taken up for further consideration on the next date. From a perusal of the above quoted order, it would reveal that this court had made a specific query upon the learned counsel appearing on behalf of the central government as to whether the Department of Pension and Pensioners' Welfare have taken any decision in pursuance to the clarification which was sought for. On the said query, the learned counsel appearing on behalf of the central government submitted that he would like to file an affidavit in that regard. It is further apparent that from a perusal of the order dated 21/2023 and 23/2023 that the instructions which were sought from the central government was not forthcoming. while hearing the matter again on 11/4/2020, on 28/3/2023, this court found from a perusal of the materials on record that there is no material except the instruction, except the submission made by the learned counsel for the petitioner, that the petitioner would opt for the government pension. Under such circumstances, this court, by an order dated 28/3/2023, opined that if the petitioner wants to opt for this government pension, there has to be a clear and unequivocal stand being taken by way of an affidavit to the effect that she would forego the employees' provident fund and will opt for the family pension under the central government. And further to that she would have no objection to recovery of the amounts already paid to the petitioner towards family pension under the employees' provident fund pension scheme. And if the said amount payable by her under the employees' provident fund scheme is recovered from the area to which the petitioner is otherwise entitled from the government pension. Accordingly, this matter was fixed on 11/4/2023. It further transpires that pursuant thereto, on 4/4/2023, the petitioner had filed an affidavit the contents of paragraph 1 to 4 of the said affidavit being relevant is reproduced herein under page 148 of Pagode. From a perusal of the said affidavit, it transpires that the petitioner have duly admitted that she is getting the family pension under the Employees Provident Fund pension scheme after the death of her husband since 2021/4/2020 till date. The petitioner had further agreed to forego her family pension under the Employees Provident Fund pension scheme if the family pension under the central government is allowed. Since the date of retirement of her husband on 28/2/2017. It has further been mentioned that the petitioner had no objection in the event that the entire amount of family pension under the Employees Provident Fund pension scheme received by herself and her deceased husband during his lifetime is recovered from the amount of area pension on being paid and being allowed the government pension to her formally. Mr. Medi, next time when you file, there's a difference between the spelling deceased and disease. What have you mentioned out here in your affidavit? See? You have before a high court, you don't mention it in this manner. My deceased husband. What do you mean by disease? Disease would be, I think he is ailing.
Yes,
No.
wrong. Wrong with it.
Then why you are not careful in filing an affidavit?
Yes, my lord. Next time I will not.
Huh?
Next time I will not.
Next time. I've also heard the learned counsel for the petitioner as well as the learned counsel appearing on behalf of the respondents. Mr. M.K. Mojumdar, the learned counsel appearing on behalf of the respondent number 10, 9 and 10, had submitted that as per his instructions, the total amount which the petitioner as well as her husband have received on account of pension and family pension from the EPFO as on April 2023
Up to March.
up to March 2023 is rupees 8 lakhs
73,000.
70
3,000.
73,000
344.
344
45.
45. Upon this court also, upon hearing the learned counsel for the petitioner, while hearing the matter, this court, the learned counsel for who wants to show this? Madras High Court? Him? You. The learned counsel for the Airport Authority of India, drawing the attention to the office memorandum dated 11/1/2022 and the reference being made to an order passed by the High Court of Madras, have also placed the order dated 15/5/12/2019 passed by the High Court of Madras in WPC number 12228 of 2019. A perusal of the said order would reveal that the facts were similar. Insofar as opting for the perusal of the said order would reveal that the petitioner therein taking into account that the pension in terms with the Tamil Nadu pension rules was more beneficial. Opted for the Tamil Nadu pension under the said rules, thereby foregoing the pension as well as the family pension in terms with the as sanctioned by the Employees Provident Fund Authority. It further reveals from the order dated 5/12/2019 that the learned single judge of the Madras High Court had taken into consideration an order being passed by the division bench of the Madras High Court in writ appeal number 1246/2009, dated 18/8/2010. Wherein the division bench held that the respondents were not justified in denying the family pension to the appellant therein, solely on the ground that she was receiving pension under the Employees Provident Fund scheme. And accordingly directed that the appellant therein would be entitled to the family pension in terms with the Tamil Nadu pension rules. And there shall be a deduction of the Employees Provident Fund pension paid to the appellant for the period during which the appellant as well as her husband had received. It is also relevant to take note of that the said order of the division bench of the Madras High Court dated 18/8/2010 in writ appeal number 1246/2009 were challenged before the Supreme Court. By filing a special leave to appeal, bracket C, number 8381/2011, and the Supreme Court had dismissed the said special leave to appeal by an order dated 13/5/2011. Taking into account the same, the learned single judge of the Madras High Court, by its order dated 5/12/2019, observed that paragraph number 13 as hereindunder. Good. Huh? This court, upon perusal of the order dated 5/12/2019, the facts involved in the instant case, as well as the office memorandums dated 11/1/2022, office memorandum.
The data same, the mark 2
bearing number 12545/194/2021 dash F dot I dash MOCA bracket 205886 bracket close, and oh, is the same number.
Please, my lord, forwarding is to other persons, my lord, and that para 7 has been included.
Huh?
The next.
Understood. That I have already recorded in my earlier order. And the office memorandum issued by the Ministry of Civil Aviations, Government of India, dated 11/1/2022. Is of the opinion that the petitioner herein would also be entitled to choose between the pension under the CCS. What is that pension?
Government pension.
Government pension under what? Where is the government? Central government? Central government is blank.
This is page 146. With all the picture.
CCS pension rules.
Not.
1972.
Not.
You लिख रहे थे last time too. Under the CCS pension rules, 1972, as well as the pension under the EPS.95 scheme. Subject to the petitioner foregoing all such benefits which the petitioner or her husband have received under the pension scheme and under the pension under the EPS 95 scheme. Accordingly, this court therefore disposes of this writ petition by taking into account the said affidavits so filed by the petitioner on 4/4/2023 and with the direction to the petitioner to submit a fresh representation to whom? Airport Authority. Representation to whom?
Civil aviation.
Hmm?
Or it could be routed through airport authority.
Airport Authority or the Ministry of Civil Aviation.
Ministry of Civil Aviation routed through airport.
Submitted representation to the Airport Authority of India. To whom?
Regional executive.
To the respondent number 2. who shall thereupon forward the same to the whom would it be forwarded? To the Ministry of Civil Aviation. Where is Mr. K.C. Gogoi? Oh,
My lord may indicate to the competent authority.
to the competent authority. Clearly spelling out our option to forego the employees' provident fund pensions, family pension, and to opt for the family pension under the CCS pension rules 1972. This representation shall be given within a period of how much? 2 weeks?
2 weeks, 2 weeks,
How much time?
2 weeks.
Be given within a period of 3 weeks. Along with a certified copy of the instant order. The respondent number 2, upon receipt of the said representation, shall collect all the service details of the husband of the petitioner and other details regarding the pension received under the Employees Provident Fund pensions, family pension scheme, family pension received under the Employees Provident Fund family pension, till such date, and thereupon forward the same to the concerned authority. That is the problem, no? Then otherwise tomorrow contempt will be there. To whom? We direct these people to the Secretary, Ministry of Civil Aviation. Then contempt will be against them. The respond number 6 koi dibo, huh? On receipt of the same, the respondent number 6 shall stop the payment of the pension under shall collect and forward the same to the respondent number 6 as well as the respondent number 9. On receipt of the same, the respondent number 9 shall stop the payment of pension under the Employees Provident Fund Family Pension Scheme, and thereupon shall forward the papers again back to the respondent number 2. The respondent number 2 shall thereupon forward the entire records to the respondent number 6. The respondent number 6 shall consider the entitlement of the petitioner for family pension under the CCS pension rules 1972 and forward the same to the respondent number 10. The respondent number 10 shall thereafter issue the government order, and thereafter the petitioner shall start receiving the family pension under the CCS pension rules 1972. The whole process shall be completed within a period of 12 weeks from the date of receipt of this order, from the date of receipt of the representation, as directed herein above. Now he is appearing for respondent number 9. 10 is different. 10 is
10 by
central
central
government.
government.
10 is him, na?
10
10 by
she
central.
appears, madam.
10 is you. You are not appearing for 10.
They have appeared.
Non-metro because so and so. Here is the building Airport Authority of India. Canteen building of Airport Authority of India. Non. 10 is you. Don't know for whom you are representing.
Part of the civil aviation.
चलो Done. Take only.
My area amount is calculate. Then generally I will be able to pay the
You
amount.
place all your area amounts and all. I'll take that area
Area amount
for Iman
since
along
rate
with
of
the.
retirement till today. We pay, then and then they will get there.
It is made clear that the respondent number 2, before forwarding the documents to the respondent number 9 or number 6, respondent number 9 shall also take into consideration the amount which the petitioner is entitled in terms with the CCS rules, pension rules 1972. From the date of retirement of her husband, that is 1/3/2017. From the date of entitlement of the husband of the petitioner, that is 1/3/2017. And also deduct the amount to which the petitioner have already been entitled to under the EPFO.
My lord, one thing, my lord, EPFO is not to calculate the matter. My lord. So only the EPFO is paying the amount, the pension part. So
No,
it will be from 2 to 6 again, not to the 9. Because 9 will not forward anything, because 9 is paying the pension part, whatever being accumulated here.
No. You see, 2 shall make the calculation
My lord.
on the basis of the representation.
Lord.
I think 2 will also ask 9 how much it has been paid.
That part.
That is okay. Once that calculation is made, then 2 will inform 9 to stop the pension.
My lord.
Once, then you have to stop it. And then 2 will write to 10. 2 will write to 6 and 10. And so that she gets the pension.
She gets the amount. So that much of it.
Article 3. Don't hold it. Tricky matter. Yes. Oh, this matter. You submitted your written submission?
Yes,
What is that? I have not got the written submission.
No, right.
But Mr. Dasgupta, tell me, do you come within the Assam pension rules? If you don't come, matter ends. This is a policy. What you are challenging out here is more of a policy that the government have also to give benefit to those people. But to ask for a pension has to spring from the statute. And you don't come within the statute. And not only that, there are many judgments. There's 1 or 2, 3 judgments that day I have referred to in another case, wherein it says that it's very sad that a person is not entitled to pension, family pension, because he has not got 1 year of regular service. But then also, the law is law. Help it.
Some public assistance may be taken in terms of Article 46. That is my endeavor.
Understood, but you see, Article 14 will.
Article, so for my case is that Article 38. Now, may I read this written argument, sir? If your lordship permits me, or your lordship may fix. Yes, I may not be entitled to pension under the pension rule. That may be correct. But one thing is that, Lord, I have rendered my service till that my date of return, and my service was utilized. My service was utilized for the benefit of the student under this Act, 2009 Act, Lord. As my service was essential, and you have utilized my service, Lord, I am entitled to something. Yes, maybe so, that I may not entitled to my pension under the pension rule. But it is a big case where the government should consider my case to the effect that I may have some public assistance as contemplated under Article 46. But that is my case before your lordship. In order to fortify that case, that's what I have stated. I have structured my case that preamble of the Constitution. Preamble of the Constitution stipulates that the India, that we the people of India shall constitute India as a sovereign democratic republic for the purpose of securing justice, liberty, and and equality. Justice, equality, and liberty. Lord, and it is fortified in the article, in the preamble itself. And this preamble was written on 26th November 1949.
Paragraph 46.
Is there any judgment?
Yes, to see this judgment, the problem arises of this. The law is well settled on this. Let's read paragraph 46.
No, yes, Mary. He was in a work charge employee. Husband was in work charge employee, and he has
No, if we are a work charge employee, that there are many cases like not only that, if there are reference to many other judgments also. You
Yes.
see, the concept is, yes, it is true, but you have to get your right from the statute. There's another judgment of out there in the compilation, a judgment of Justice Bhima Kohli, a recent judgment, wherein it has been mentioned that the right to get a pension is on the basis of a statute. And if you don't come within it, you can't help it. That is the problem. Because what is going to happen, Mr. Rajgupta, if anything is done with this is not your only case. There are hundreds and thousands of cases in Guwahati itself, in Assam itself, where they are hesitating on that. I have been rendering long years of service in another place. Just for example, take the case of excess teachers. Excess teachers. They were appointed in the year 89-91. They rendered their service, continued in the rendering the service. Thereupon, there is a committee which has been formed and found that no, these appointments were okay, but they were in excess of their posts.
Not holding the substantive post.
No. What actually, if you see, there was one post in a particular school. But against this one post,
3 teachers were appointed.
10 teachers were appointed. They were appointed right, but against it. This is how it is done. It is beyond the rules. But they worked. And then they were regularized subsequently in 2002, 2007, 2008, they were regularized. It's a different thing. But they were asking that earlier periods should be taken into account. That can't be taken into account because of Rule 31. Rule 31 is clear on that. So unless Rule 31, 1 and 2, more particularly if 1 and 2 is waived by the governor, 1 and 2 the governor can waive. However, not the third. Third, you come within it. But 1 and 2, I think you were receiving salaries from the government?
They were receiving salary.
From the government? So 1 and 2 is as regards whether they were in government service as well as in permanent or substantive. These two can be waived by a governor by giving a declaration. But not the third one. So if that is done, then you will come in because you have been all along receiving. And that waiving can be done in terms with that proviso of 31.
My case is more worse than that, because so far I am concerned that I was not even appointed as a government servant.
No, but did you get the salary?
No.
You have not got a salary.
I will not get that salary.
You have been working without a salary for the last so many years. Then, what right do you have?
So I should point out this thing. It is not that I was appointed, I got my salary from the government as a master role employee or the workers employee or the ad hoc employee. I rendered my service as a might.
But you didn't get any salary.
I did not get any. At that point of time, the law was that a person concerned who worked for a period of more than 10 years, he is entitled to be employment. So I worked there and I approved before the Honorable Guwahati High Court. The Honorable Guwahati High Court passed an order to the effect to consider my case. My case was not considered. Then I approached before this Honorable Court by initiating a contempt. In the contempt proceeding, the government took the plea that as you were not employed in a as you are employed in a government provincial school, so your service cannot be regularized. That created a trouble to me. Then I approached before the division bench by filing a writ appeal, and that writ appeal was also not considered. That In that it appeal some observations were made. In that way, I attend my age of superannuation in the year 2012. So my endeavor before your lordship that I have rendered my service for this reason or that reason. I am whether I may not get pension under the existing pension rules because I was not an employee. So whether my case can be considered or not to have some public assistance, because that is my case before your lord.
And Mr. Dasgupta, it's a very difficult thing.
Very difficult, I understood. But
No,
let me-
I'm not. You see, if it is one in a case, this court could have granted. But this will open floodgates.
Yes, sir, that may open floodgates. So
There are so many teachers. If you see, more particularly on Monday, Wednesday, and here, the first 10 or 15 matters which comes in the admission, all are 2015, 14 matter. All are cases where 89 onwards, they have been rendering service. Not a single penny has been paid, but they are rendering service.
and he was more particularly, I was serving under the BTC, not on the government of.
The problem which arises with these,
Whether the
This-
BTC can frame a scheme or not, that may kindly be up for this type of teaching.
there is no scheme.
There is no scheme. It's not that I have not.
In fact, nowadays,
Whether they can frame a scheme for these people or not, that can be examined. And it is not that I have not got some government report, inspection reports are there. They can-
no,
they can
one thing
frame a
that is,
scheme, at least for this type of person, that can may kindly be examined and not.
this type of persons means in many cases you will find.
No, not many.
Yes, Mr. Dasgupta, every day I am getting. Isn't it, Mr. Shah? Every day there are many cases on this. They have been working without a single salary. This court had on various occasions pointed out that once a school is provincialized, it becomes the property of the government.
Yes, sir.
There's no quarrel. If you see from 1968, the Education Act, every provision, when once the school is provincialized, it becomes the property of the government. How a person who is not in the school, how is he still working?
The managing committee of the school has appointed him. Because of the fact that there is a scarcity of teachers, lots of teachers. Some teachers are essential. And for that purpose, the managing committee has appointed.
Now, how a school, after it becomes the property of the government, somebody else can be allowed? Would the same thing apply in respect to an office in the PWD? Or his GMC? Would you allow somebody? No. The GMC, nobody else can enter and work out there if he's not appointed. But how is he doing it in the school? And it is still continuing. Every day there are affidavits being filed to that effect. Yes, he is working, but no, he was never appointed. This is every day the issue out there. But this court fails to understand how is it possible. Now the government says, in some cases, "Hey, look here, we have been. Just if you see the preface of the judgment in the case of Jibon Chandra Dekka, you see, these schools have been provincialized, but these teachers were drop teachers. And they have been working out there continuously and they have been agitating, and the government have taken a decision that, look here, we'll do one thing, we'll provincialize your services. We'll also bring you to the fold of the government school. Anyway, this is the stand of the government that we are doing it. But once a school is being provincialized, how can there be an appointment by the authorities, by the school managing committee thereafter, without anything?
She has been working since 1975.
1975?
75.
Understood. But when was the school provincialized?
Prior to that,
So it must have been under the 68 Act or maybe under the 74 Act. It has to be under the 74 Act because 74 Act brings in 68 Act was there, then earlier to that you had the 54.
She was appointed in the year 1975. And she served there till 2012.
But it was a provincialized school.
At that point of time, when she was appointed, that time it
Was it a provincialized or a government school? It seemed to be a government because 74 the act had come. The
No, this was
provincialization.
provincialized.
Prior to that was the 68 Act. Huh?
67.
67. Oh, so this has to be under the 51 or 54 Act before even the 68 Act. So it was a government school. Okay, we will. You want to hear it today?
Day after tomorrow or any day.
I'll pass the order itself today, itself, but I can't help you with this. Day after tomorrow.
Not tomorrow.
Okay, day after tomorrow. They are not. We'll have it on 2nd of May.
No problem.
Item number 27 and 28. Pronouncement of judgment versus order.
Accordingly, both the writ petition stands disposed of with the following observations and directions. The order of compulsory retirement dated 25/3/2020 calls for no interference, save and except that the order of compulsory retirement dated 25/3/2020 shall be effective from 25/3/2020. The petitioner shall be entitled to 3 months' pay along with all allowances with effect from 25/3/2020. The said amount be disbursed by the respondent authorities within a period of 2 months from the date a certified copy of the instant judgment is served upon the respondent number 2. Any delay after the stipulated period herein given would entail interest at the rate of 12% from the date of such default. The petitioner would be able to retain the present accommodation for a period of 1 month from today, and thereafter the petitioner is directed to vacate the residential quarter. If the petitioner fails to vacate, the respondent authorities would be at liberty to take such action as deemed fit in accordance with law. There shall be no order for costs.
Much obliged.
Report করবো
Item number 29 and 30.
Consequently, this court therefore disposes of both the writ petitions with the following observations and directions. The communication dated 13/9/2021 issued by the Block Elementary Education Officer is set aside in court. The respondent authorities are directed not to make any recovery from the petitioner in any mode, including from the retirement dues of the petitioner. The amount of rupees 17,07,100, which was computed to be the excess payment drawn by the petitioner on account of overstay. The respondent authority is directed to fix the retirement benefits of the petitioner on the basis of the petitioner's actual date of superannuation, that is on 31/1/2018, which is based upon the date of birth as recorded in the HSLC. The respondent authorities, including the Elementary Education Department and the Director of Pension, are directed to immediately process the pension of the petitioner so that the petitioner receives his arrear pension as well as all other pensionary benefits at the earliest. The said exercise be completed within a period of 4 months from the date a certified copy of the instant judgment and order is served upon the Director of Elementary Education as well as the Director of Pension. This court further directs that upon the formalities being completed by the Elementary Education Department as well as the Director of Pension, the concerned Treasury Officer shall do the needful so that the petitioner receives his arrear pension, regular pension, as well as the pensionary benefits to which the petitioner is otherwise entitled. Before parting with the record, this court finds it relevant to observe that it has become a recurrent phenomenon, as can be noticed on every other day, relating to litigations filed challenging recovery or proposed recovery on account of overstay in service. These notices for recovery or recovery so made by the concerned department wherein the employee had worked come to light at a very late stage after the actual date of superannuation. Either it comes to light at the behest of the employee or a vigilant official of the department, and mostly when the Director of Pension or the Office of the Principal Accountant General AE points out the deficiency as regards the date of birth which have resulted in overstay. It can also be seen that when such deficiency is pointed out, the concerned department issues notice for recovery to the employee or recovers from the employee. The law laid down in Pandit Jagadeshwar Prasad Supra and Rafiq Masi, Whitewater Supra, being well settled, it is not known why the concerned departments, or for that matter the officials responsible for issuing superannuation notices, are not vigilant. In fact, the present case is an epitome of the lack of vigilance and the diligence on the part of the officer who was required to see that the date of birth of the petitioner ought to have been inserted in the service book. This court further fails to understand that in the present case, where so much present age, where so much impetus is given to digitalization, how the issue as regards the date of birth and date of superannuation can still continue to remain an issue on the ground that the service book was not available. It is also relevant to observe that what is normally seen is that the concerned department, when it realizes that there is an overstay by an employee, steps are taken to recover from the employee who has retired, but no action is taken on the erring official for whose lack of diligence for not recording the date of birth or issuing the superannuation notice in time. The steps for recovery or notice of recovery are issued. If the state government is serious to root out the problem of overstay, the state government is required to take appropriate steps by not only holding the retiring employee accountable, if there is a case of fraud or misrepresentation, but also take steps. But also steps are required to be taken against such erring official for whose lack of diligence and vigilance it has led to overstay. This court also feels that steps are also required to be taken to digitalize the service records of the employees so that not only the official who is required to issue the superannuation notice can do so without any hindrance, but the senior officials of the department can also keep a tab as to whether the official required to take steps for issuance of superannuation notice is doing so. This court hopes and expects that the government of Assam, in its own wisdom, shall take appropriate steps so that the malady of the present kind do not continue. Pending applications, if any, and I hope they do some.
Lordship, Lord. On the last occasion, as the learned Advocate General also
I've asked him,
Lordship.
because otherwise, every time this goes on.
Lordship, Lord. And this requires some
If it is digitalized, because every time if I can see, it is on account of the service book not available. Service book he has not given.
Lord.
Here I have recorded. It surprised this court to take note of that the official who had signed on 30/3/2007 in the service book did not find it relevant for insertion of the date of birth in the service book of the petitioner, or to insist to have the date of birth of the petitioner inserted as per column 7 of the service book. If the said aspect of the matter would have been done in the year 2007, that is the date on which the official had put his signature, then the petitioner would not have continued in his service beyond the permissible date of retirement. It is also relevant to mention that although in the affidavit in opposition filed by the Director of Elementary Education, there has been a mention that the service book was in the custody of the petitioner, but this court finds it difficult to accept the state contention on the ground that the service book, as per the established norms insofar as the petitioner is concerned, is required to be maintained in the office of the Block Elementary Education Officer. There is also no documents enclosed to the affidavit filed by the respondents herein that the respondent authorities have asked the petitioner to submit the service book to the authorities concerned. Be that as it may, this court finds it shocking that the official concerned had signed on the service book on 30/3/2007 and did not insist that the date of birth of the petitioner be inserted as is required in terms with column number 7 of the service book. It is further necessary to take note of that there is no allegation of any fraud. Further to that, I have also mentioned about how this has happened. Yes. I perused the service book so produced by the Elementary Education Department. It appears from the service book that the official who has put the signature is the Block Elementary Education Officer Pachim Nolbari. Surprisingly, in the column number 7 of the service book, which is a column pertaining to inverted comma date of birth of the Christian era as nearly as can be asserted, the same has been kept blank, and there is a signature of the Block Elementary area with the date being inserted as 30/3/2007. This is almost 11 years prior to the petitioner's actual date of retirement. It further transpires that there are further attestations being made in the service book by the Block Elementary Education Officer on 30/3/2007 and 30/12/2011. Subsequent thereto, although there have been various attestations being made by the Block Elementary Education Officer Pachim Nolbari, there is no date put against such attestation. It further appears that the very Block Elementary Education Officer who did not put the date against the attestation so made was the official concerned who also put the endorsement in the service book to the effect retired on 31/1/2018 as per the HSLC certificate. And this very officer had also issued the communication dated as would appear from the signature. I think this judgment you should place it before the director of this Department of Personnel. so that they issue something. Otherwise, Rule 95 has become useless.
We'll communicate.
Once you take action against the erring official, then they will be
There
useful.
will be a lot.
Then we won't see a branch of litigation. Yes, any urgent matter I'll take up, otherwise not necessary. Hearing? Yes, Mr. Goswami, what matter?
My item is 17, madam. We can wait. It will take some time, man. Some other day.
Hi, please, your lordship. Lordship, item number 19, may a short date be fixed. It's part third matter.
It's a part matter.
Yes, lordship,
Which one?
before you only.
Huh?
Before you only, it's a part third matter.
Which one?
You had two inquiries, Sabita Tamuli, 7688.
Oh, what is the matter about?
The matter is regarding this non-payment of this. I'm so sorry, Lordship. The matter is regarding impugned order of AIDC regarding they have fixed 7600.
Oh,
late
that
pay.
one. That I remember. Where is
Yeah.
Mr. J.K. Goswami? He's the person who is doing it.
Yes, Lordship.
We'll have it on some other day. I have not put it as part of.
But Lordship, you had two inquiries.
No, I remember that matter. That is 7600 was the great pay which was given.
Yes, yes, Lordship.
There was this financial upgradation which was given,
Yes,
isn't
Lordship.
it so?
Yes, Lordship.
I remember.
May a short date be granted.
Okay. Have it when? 4th of May.
4th of much obliged.
Because item number 16, the petitioner expired on 4/6/18, and his all allegation has been settled. So, I am for a respondent.
Item number 16.
16.
Where is the petitioner?
Not there, but he expired on 4/6/18. Year 18 he expired during his service period.
You are there?
No, no, Lordship.
16.
16.
16, your husband is there. Your husband is there, Lord. Mr. Utpal husband, and there I have not seen in the court, Lord.
Chalo, it will come some other day then.
Lordship, a date after 10th of May, the senior
Oh.
counsel will not.
You
be-
said urgency. No problem.
Lordship, the senior counsel will not be in Assam. He has a matter in Supreme Court.
We'll have it on 23rd of May. Anything? Any other matters? No. Urgency? No urgency.